So for the court again on docket number 3869 of the year 2023, charged with assault and battery on a family or household member. This offense allegedly took place November 18th at 50 Battery Street, number 103.
All right, so sir, the court will enter a plea of not guilty on your behalf. We'll accept the appearance of Attorney Pelletier. Commonwealth, would you like to be heard?
Yes, Judge. Good morning, Your Honor. 88 Mark Tomei on behalf of the Commonwealth.
Morning.
Judge, the Commonwealth is just seeking personal recognizance. We're going to ask for a pretrial date. I've spoken to my brother about some dates that work for both parties. The Commonwealth has filed a motion, as well as completing a 276-56A form. At this time, Judge, the court wants to hear a recitation of the facts. I'm happy to provide it.
Why don't you give a brief recitation of the facts?
Sure, Judge. Judge, the facts in this case allege that approximately 1 o'clock in the morning on Saturday, November 18th of this year, officers did respond to a radio call for an assault and battery at 50 Battery Street here in Boston. Operations relayed to the responding officers that the reporting party, the victim in this case, had called and stated that the defendant attempted to choke her. It was also relayed that this victim left the apartment, was located by officers in the lobby of the building, while the defendant was located inside of the apartment itself. Upon arrival, officers met with the victim inside of the lobby. This victim did state her name. She further stated the defendant's name, and at that time she stated that during the evening, the defendant could not locate his cell phone after returning to the apartment from a night out. She further stated the defendant began yelling at her, demanding his phone back, and believing that she had hid the defendant's phone. The victim further stated she did not have his cell phone, did not know where it was located. And at that time, she stated that she attempted to walk away from the situation, and at which time she was grabbed by her hair and pulled backwards. Furthermore, this individual stated that during this process, the defendant stated to her that she was not going anywhere. At that time, officers did observe redness on the victim's chest area. They did ask her if the defendant attempted to strangle her during the incident. She responded in the negative, Judge, saying that he did not. She also declined to be seen by EMS. And at that time, she also stated the defendant was consuming alcohol during the evening. Officers notified their patrol supervisor. Response was initiated. Photographs were taken of the apparent injuries. At that time, she was also provided with a copy of her victim's rights under 209A. At that time, officers remained with the victim while additional officers who responded went to speak with the defendant. And prior to doing so, a check was done for any orders or warrants. There were none. Furthermore, officers proceeded to the apartment. They made contact with the defendant. He appeared intoxicated when he answered the door. He stated to officers that nothing had happened, and he did not attempt to provide any explanation at that time. He was informed of the allegations made against him, that he would be taken into custody. The defendant was cooperative, indicated that he understood, and at that time he was escorted upstairs to retrieve his belongings. While they were up in the apartment, they observed a broken lamp on one of the nightstands and what appeared to be a small amount of broken glass on the floor. Those are essentially the facts of the case, Your Honor. Based on the defendant's board probation record, the facts of the case, as well as all other circumstances, we are asking for personal recognizance. We're asking the court to consider bail conditions to be a no-abuse order and for the defendant to refrain from consuming alcohol during the pendency of the case.
All right, thank you. Attorney Pelletier?
We're in agreement with the court's request for personal recognizance and the conditions of no abuse and refraining from alcohol.
All right, do you have a motion before the court?
I do, Your Honor. I filed a motion for us to have an unredacted version of the police report. I believe there are some redactions in there.
All right, Commonwealth, any position on that?
No objection to that motion, Judge.
All right, I'm going to allow that motion. Commonwealth, you have a motion as well.
That's correct, Your Honor. I provided that motion to the court. It has to be heard at sidebar if the court wants an explanation on it, but I do believe we provide our reasoning on the face of the report, but I'm happy to speak at sidebar.
Well, why don't I do this? I'll allow the motion without prejudice. All right,
thank you, Judge.
At this time. So it'll be a personal recognizance. Those conditions of release will be in effect during the pendency of the case. No abuse of the complaining witness, and the defendant is ordered to refrain from alcohol during the pendency of the case. Now, you set a date for pretrial, correct?
Correct, Judge.
All right. What date would you like, Attorney Pelletier?
Either January 19th or 26th, whatever works best for the court.
All right. Why don't we go with the 19th? All right. January 19th for pretrial hearing.
Thank you, Judge. Thank you, Madam Clerk.
All right. Thank you.
Bill.
Bill. Yeah. Exactly.
Milan Lucic, docket number 3869 of the year 2023. The court has entered a plea of not guilty on your behalf. You'll be released on your personal cognizance to return back to court on January 19th. The matter will be called in quorum 14 and marked for a pretrial hearing. As conditions of your release, you are to be rearrested during the pendency of this case, or you pick up any new offenses. Your bail could be revoked and you could be held for up to 90 days. You're also not to abuse the alleged victim, and you are to refrain from alcohol during the pendency of this case. Allegations of domestic abuse were filed and facts were found sufficient. The Commonwealth's motion to impound or redact confidential information has been allowed. The defendant's motion to release an unredacted police narrative has also been allowed.
Your Honor, would the court waive Mr. Lucic's presence in the next court date?
Any position on that, Commonwealth?
No, Your Honor, it's a relatively short date. That's fine with the Commonwealth.
How about if he appears virtually via Zoom?
Yeah, I can do that.
All right?
Okay, that's fine.
We'll give him instructions about how to do that.
The docket reflect that you may appear via Zoom on January 19th. Thank you.
All right, thank you.
Thank you, everyone.
Thank you, Your Honor. Thank you.